Welcome back into Eye on Agriculture. I'm Brityne Rucker. A recent opinion by the Kansas Court of Appeals provides a thorough explanation of property rights with respect to road ditch right-of-ways, as well as the common law of trespass and nuisance. To help walk us through this, we're joined now with Roger McEowen, professor of agricultural law and taxation at Washburn University. Roger, give us some background on the Ross versus Nuisance case.
Well, good to be with you, Britt. This is a pretty tough case that's been brewing out in Norton and Phillips County for quite some time. But we had a hog farmer that needed to get rid of hog waste, and his idea was to pipe it 2 miles down the road ditch past a couple of his neighboring farmers and hook it into his pivot irrigation in a field that he owned across the road from from the plaintiff's farmhouse. Basically, the short story out of this is you can't just use a road ditch unless you have permission to do so by the adjacent landowners, or you have the permits from the county to do so, or you have some state law that says you can do that, because the adjacent owners to that road own the road ditch.
So, Roger, really quickly, what is the big takeaway from this case?
The big takeaway is that the Court of Appeals upheld property rights of adjacent landowners. You can't have your road ditch appropriated for somebody else's private purpose. You own that, and that the right to farm law does not protect you if you're in violation of state law somehow.
Well, thanks so much for coming on today and chatting with us. Everyone, stick around. Eye on Ag will be back after the break.